The next case is State of Ohio versus John R. Davis. My colleague has just reminded me that instead of using that podium in the back, would you please use the podium in the front? Each side will have 15 minutes, and the appellant may reserve up to 5 minutes if you wish to do so. You may proceed.
Thank you. Thank you, and may it please the court, my name is Ron Fry. I represent the appellant in this case, Mr. John Davis. Respectfully reserve 5 minutes for rebuttal. The issue in this case is whether the trial court erred when it denied defendant appellant's motion to suppress. As the court knows, the standard in this case is a mixed question of fact and law, whereby the court must accept the trial court's findings of fact if they are supported by competent and credible evidence. Then independently determine, without the deference to the trial court's conclusion, whether the facts satisfy the applicable legal standard. In this case, Mr. Davis pled no contest pursuant to Criminal Rule 12 and preserved his right to appeal the issues with regard to the motion to suppress. The trial court's findings of fact are not supported by competent or credible evidence. In this case, it was found that Mr. Davis crossed over the marked lines and that the sergeant observed the vehicle travel over the right side solid marked line while the trooper was situated in the crossover on Interstate 80. The trooper was initially in the crossover on Interstate 80 and he was observing traffic approaching the crossover traveling eastbound on Interstate 80. It's a 3-lane highway and Mr. Davis was traveling in a large Yukon, a large SUV vehicle. That vehicle was going approximately 58 to 60 miles per hour in the far right lane. So he's essentially 2 lanes across in the 3rd lane, and the trooper testified that the wheels on the passenger side of that vehicle crossed over the marked lanes at the point when the vehicle passed the trooper who was stationed perpendicular to the interstate at the crossover.
So he crossed over the line to his left.
To his right.
To his right. Into the shoulder.
Into the shoulder,
right.
Correct. Passenger side of the large Yukon. The trooper then exited the crossover and proceeded behind the Yukon. However, it's a 3-lane highway, so when he exited the crossover, the trooper remained in the far left lane, and the Yukon remained in the far right lane. At that point, the trooper indicated that he observed the Yukon cross over the line approximately 3 or 4 times. Ultimately, the dash cam video did come on. He could not recall if he manually started the dash cam recording or if it came on at the initiation of the sirens or the lights automatically. However, a review of the dash cam video, which is part of the record in this case, clearly demonstrates that nowhere on the video can you really observe Mr. Davis going over the line. Now, the trooper explained that perhaps you can on the video in some points, but he couldn't discern exactly where. And he also testified that the violations that he observed also would have occurred prior to that. However, I do think it's important to point out that the trooper tried to discern from the video if there were any crossovers or any touching of the line, and he couldn't pinpoint any specific spot. And when you review the video, it does capture very accurately that Mr. Davis is traveling within the lane of travel. With regard to...
Excuse me,
yes.
On that point, is it clear enough that the distance between the left side of your client's car and the immediate line to his left was not sufficiently clear in order for the trooper to conclude that he had to have gone over the line, even though he couldn't see the right line?
The trooper claims that he could see the right line
Okay.
In real time. So on the passenger side, that's where the alleged
Violation occurred.
So, and on the video, you can see very clearly that Mr. Davis is operating the vehicle really perfectly, frankly, within the lane of traffic. And that video, I believe, goes on for about 57 seconds. So any violation would have allegedly occurred prior to the video recording commenced. But again, looking at the vantage point at which the trooper would have been stationed within the crossover and the angles that would have been in play, the ability to accurately gauge the location of the passenger side wheels with regard to the shoulder line would have been difficult to, perhaps impossible to gauge with any accuracy. And again, the standard for a marked lanes violation wouldn't simply be touching the line. There would have to be an actual crossover pursuant to the case law.
The
Yes.
trial court apparently credited the officer's testimony, and the state has said that, that would be sufficient, the officer's testimony, when credited by the trial court, would be sufficient with or without a video. Can you agree with that?
The officer's testimony can be sufficient with or without video. That is correct. However, in this case, with the dash cam video, I think it points out a couple of issues. Number one, the dash cam video clearly shows that Mr. Davis was traveling within a lane of travel basically perfectly once the camera came up. And secondly, the vantage points and the angles at which the trooper was stationed, again, given the fact that we're dealing with a large SUV 3 lanes over traveling at 60 miles per hour, the officer being stationary within his vehicle to try to observe the wheels in relation to the shoulder line on the opposite side of the large SUV as to whether they actually went over or not, or simply touched or didn't touch at all, would be very difficult. And as the trooper testified, he was even trying to conduct that same analysis with the video that he was viewing to see if he could pinpoint where it was. And he had difficulty doing that, and ultimately said he could not point to a specific point in time where there was in fact a crossover. The idea that this vehicle went over the line 3, 4, maybe 5 times, depending on the way that the testimony is understood, but for a period of approximately 57 seconds in the video, doesn't even come near either of the lines. I think it calls into question some of the accuracy as to the ability to gauge the angles from the viewpoint that the trooper was positioned at.
Excuse me, did the
Yes.
trooper or the video indicate that the car was weaving rather than just going straight, but closer to the line or improperly over the line?
The trooper's testimony, I don't believe he said the word weaving, but he clearly indicated that his observation included crossing the line perhaps 3 to 4 times. The video, upon review, I don't believe that it indicates any weaving of any sort. As soon as the officer initiated the stop, the Yukon did come to a stop. In addition to the reasonable suspicion to stop in this case, there's also the length of the detention. The trial court found that the detention was no longer than necessary to effectuate the purpose of the stop. The only reason Mr. Davis was stopped was because of the alleged lane violation. That is not in dispute. He was subjected to questioning regarding where he was traveling. He was subjected to questioning regarding boxes in the back of the vehicle. The trooper testified that he decided that a canine search would be conducted, a free air sniff, the term search lightly, but a canine free air sniff would be conducted. That determination was made prior to the canine being on scene. After the trooper testified that he made the determination that that search would be conducted, it's at that point when additional questioning was made with regard to the boxes in the back, the traveling destination, where Mr. Davis was coming from or going to, and also discussions about a chandelier, because Mr. Davis had indicated apparently that there were chandelier parts within the boxes in the back of the truck. It was also after he had already made that determination, and again, the canine isn't on scene yet, when the trooper then made the decision to request Mr. Davis exit his vehicle, pat him down for weapons. There weren't any. Mr. Davis was cooperative, and then positioned him within the rear of the cruiser. Again, these events all occurred after he had already made the decision to employ a canine. The canine then arrived on scene from another trooper. There's a dispute as to whether the canine was called on the scene or if it was just the trooper driving by. However, certainly the canine did arrive on scene and conduct a free air sniff at that time. The duration of the stop was unnecessarily prolonged in order to effectuate the canine free air sniff. And the court case that recently came out and that we supplemented within the record from the United States Supreme Court, Rodriguez versus United States, 575 U.S. 2015, decided in April of 2015. The authority for a seizure ends when tasks
Can
tied...
I just stop you for
Yes.
just a moment? You say that, and I read this in the brief as well, that the stop was unnecessarily prolonged. But when you look at the timing that's set forth, and I noticed that there was no reference to the time of the stop, what happened States brief, it made it appear as if all of this happened very quickly. So even though you're, arguing about extensive questioning, that has to be looked at within the context of time. If the entire stop was only, say, 10 minutes, how do we gauge what is reasonable in terms of time?
Absolutely, and you are correct. I think that the video, the dash cam video in this case speaks for itself with regard to the lapse of time. And it is true that less than 6 minutes passed from the initial contact to the actual alert. And that's represented within the video very clearly. The Rodriguez case from the United States Supreme Court, I think, answers that question. The traffic stop cannot be prolonged beyond the time needed to complete traffic inquiries. If it is, it's unlawful. And the critical question is not whether a dog sniff occurs before or after a ticket is issued, but whether the sniff adds time to the stop. And in this case, the trooper had already made the decision that he was going to deploy a canine. The canine wasn't even on scene yet. And it was the actions following that, on the marked lanes violation, after he made a decision that he was going to deploy the canine, without probable cause or reasonable suspicion of any additional crime. He made that decision, and then he engaged in the conversation. And then he also engaged in requesting him out of the vehicle. I reserve the balance of my time. Thank you.
May it please the court, my name is Natasha Guerreri and I represent the county of the state of Ohio in this matter. I guess first and foremost to the issue of the competent credible evidence of the actual mark line violation itself. As I did state in the brief and as Judge Moore indicated, there is a 10th district case, State of Ohio versus Comer, in which the appellate court there held that the testimony of an officer alone of a marked lane violation is competent credible evidence in order to support such a finding. Here, Sergeant Laughlin stated that he not only saw the marked lane violation while he was actually observing the vehicle while he was stationary, but also after he pulled out and was making his way toward the vehicle. One time, as he was stationary, 3 to 4 more times as he was following him, and did testify that in at least one of those times that the tire did completely go over that side marked line. Therefore, the state would suggest that despite the fact that the video did not necessarily capture those violations, that in and of itself does not dispute that the trial court did have competent credible evidence to make that determination.
Did the video capture the vehicle as it passed the officer while he was in the crossover?
My recollection of the video was that it started after he actually was on the road. And Sergeant Laughlin did testify that the video would not have started until after once he's initiated the stop and after those infractions that he observed. So that video would not have necessarily captured those infractions. And then with regard to the actual length of the stop, as Judge Moore pointed out, from the time that Sergeant Laughlin actually got out of his vehicle to the time that the dog was actually out and on the vehicle was about 5 to 6 minute time frame. The video shows the sergeant, after the stop was effectuated, immediately got out, went up to the vehicle and began to speak with the driver. Sergeant stated that as he approached the vehicle, he noted some U-Haul boxes were in the back. One bag was actually back there as well. Kind of piqued his interest because he had prior knowledge in cases in which U-Haul boxes were used to transport illegal narcotics. He then approached Mr. Davis, explained the reason for the stop, that it was a marked lane citation, He noticed that Mr. Davis, even despite having been explained that, was nervous, his voice was cracky, he was a bit shaky. So that also led to his suspicion of some additional activities going on. And it was after that point that there was kind of some discussion as to where he was going, a change in the story between Davis's first statement that he was going to visit his mother, then it was, I'm visiting my daughter who just had a baby. And at that point, the sergeant decided that he did want to have a dog come out and conduct a free air sniff of the vehicle. Unlike Mr. Davis would suggest, though, the sergeant did testify that Trooper Trader actually, he was about to radio him before he removed Davis from the vehicle. However, Trooper Trader actually overheard the fact that the sergeant was pulling over a vehicle, was in the area, and decided to go and assist. So the trooper was there before Sergeant even had the ability to make the call out to bring the dog over. It was at that point that the sergeant asked Mr. Davis to exit the vehicle. Mr. Davis did agree to a pat-down, he was placed in the vehicle. Sergeant Walden then told Trooper Trader to go ahead and run the dog, and he commenced to provide information to the dispatcher regarding Mr. Davis's license and registration. So this was all taking place kind of simultaneously. It doesn't appear at all from my review of the video and what was going on in the time frame that the sergeant was trying to elongate the time in order to allow the Trooper Trader to actually appear on scene, because he appeared even prior to him requesting his assistance. And it was during the time, immediately after he provided that information, you can actually hear that on the video to the dispatcher, that you can also see the trooper coming up to the vehicle, starting the sniff, and what Trooper Trader stated was an alert to the vehicle. So from the time that the sergeant actually began speaking to, or actually exiting the vehicle, to the time of the alert on the vehicle was at a little under 6 minutes. Therefore, we would argue that the trial court was correct in finding that there was competent, credible evidence that this stop was not, in fact, lengthened past the reason for the stop, because the sergeant was actually in the middle of still conducting his duties, had not finished those, and writing the citation, getting the information back from the dispatcher with regard to his reason for the stop. And in reference to Rodriguez, I believe that doesn't really change the analysis with regard to the length of the stop, because that's the law that's within the state of Ohio that this district, as well as the Ohio Supreme Court, had already been following, that you cannot prolong the reason for the stop. So the analysis here wouldn't change because of Rodriguez, because this is something that the state of Ohio has already been going through, and this has been the law here for quite some time. And again, in Rodriguez, the facts of that case were distinguishable from what we have here, in that the officer completed the stop, ran all the checks, wrote out the citation, provided the citation, explained it to the driver, and it was only after that point that he decided to not let him go, felt that he was not able to leave at that point so that a dog can come and conduct the free air sniff. And that clearly is outside of the reason for the stop, and therefore the United States Supreme Court felt that nothing that would prolong it is a constitutional stop after that point, which is distinguishable from the facts that we have here. Mr. Davis also argues that there was no competent, credible evidence with regard to the actual fact of the dog alerting to the vehicle. Here we had testimony of Trooper Trader, who was a trained narcotics canine officer, who stated that he started his search at the back of the vehicle and then proceeded toward the front of the vehicle, starting up the passenger side. And it was actually at the rear passenger area of the vehicle that he noticed a change in Argo's behaviors. He saw a head snap, his body actually turned perpendicular to the vehicle, and then he commenced to scratch, which was his alert because he is an active alert dog. There was also testimony of a Mr. Jimenez, on behalf of the defense, who was in the business of actually training dogs in this capacity for narcotics and such. He testified that he observed the video. He did agree that the dog actually did change position perpendicular to the vehicle. However, because of the view and the length of the video, he could not observe the alert itself. He stated that he could not provide an expert opinion as to whether or not the dog actually alerted to the vehicle. The state then also presented its own witness in rebuttal. Again, another certified dog trainer in the same field as Mr. Jimenez, and actually trained the dog and the officer in this case. And he also stated from the video, you can see that perpendicular movement of the dog, and he actually heard the scratching in the video based upon his experience of 29 years in training dogs and being around dogs in that capacity. Therefore, the testimony not only of Mr. Davis's expert, but as well as the state's, lend credibility to the testimony of Trooper Trader that, in fact, Argo did alert to the presence of the odor of narcotics on Mr. Davis's vehicle, or emanating from Mr. Davis's vehicle. Therefore, the state would argue that there was competent, credible evidence of that. And because of the fact that the dog did alert to the vehicle, that allowed the officers probable cause in order to search Mr. Davis's entire vehicle, lending to the discovery of 180 pounds of marijuana. The state would argue that the trial court was correct in denying Mr. Davis's motion to suppress, and that this honorable court uphold its finding that the findings of fact were based upon competent, credible evidence, and those conclusions of law were correct in this matter. No further questions for me?
Thank you.
Thank you, Your Honors.
Thank you. With regard to the canine's appearance at the scene and whether the canine was summoned or simply in the area, that was in dispute, as I indicated earlier. It's not clear. However, within Trooper Trader's report, the trooper who had the canine, he indicated, quote, "Sergeant keyed his portable radio and was calling for me to meet with him." And that's within the transcript at page 100. So there is an indication that he was in fact summoned there. And again, there was no reasonable suspicion or probable cause to indicate that any crime had occurred beyond the marked lanes violation. Nervousness is not a sufficient basis. With regard to the Rodriguez versus United States case, the key here is the de minimis nature of any extension. So it doesn't matter if we're talking about 6 minutes, it doesn't matter if we're talking about 1 minute pursuant to this holding. The facts of this case are not analogous to the facts in Rodriguez, because that stop actually concluded and then they brought the dog. But it doesn't change the nature of the holding of Rodriguez, which says you cannot unnecessarily prolong the traffic stop for another purpose. Okay? The mission of the traffic stop is what is to be completed. And in this case, it was just marked lanes.
But you're asking us to find that if an officer stops someone for a traffic violation and then they should just be blind to anything else that they see in terms of their discourse with the individual. And that's simply not, that's not supported by the precedent in this district. That if there are other issues that arise, such as a different story, or the person sweating profusely and it's in the middle of winter, or things of that nature, that the officers can take that into consideration.
That's correct, Your Honor. There can be considerations that can justify reasonable suspicion or probable cause even to extend a seizure or a search. But those factors were not in play here, and that's not what the testimony indicates in the trial transcript. We don't want to blind our officers to those sorts of considerations, that's for certain. However, when it is very clear that this is a marked lanes violation and there's no reasonable suspicion or probable cause for anything further, to extend the mission of the traffic stop to deploy a canine, to request a canine, and then make the decision pursuant to the trooper's testimony, that he's already made the decision that he's going to deploy the canine prior to even initiating much of this questioning. And much of the questioning did not concern a marked lanes violation. And having him exit the vehicle and enter the rear of the patrol car and be pat down for weapons for allegedly going over the lane, that extended this stop. And it's a de minimis extension. But Rodriguez makes clear that a de minimis extension beyond the mission and purpose of the stop simply is not acceptable. That is what the case law holds from the United States Supreme Court. Unrelated inquiries are okay. You can do that, so long as it doesn't extend the stop. And even a de minimis extension is going to raise constitutional issues. One other thing I'd like to note within the brief that we filed, the appellant was also prevented from challenging the credibility and reliability of Argo and the handler when defense counsel was unable to ask questions regarding of their own witness on their redirect of their expert witness. They were prohibited from asking regarding documents and journal entries from the Lorain County Court with regard to Argo and the trooper's past performance in other cases. That testimony was prohibited. The attorney tried on 2 different occasions, and as a result, Mr. Davis was denied his opportunity to present information and evidence in the suppression hearing. It was an abuse of discretion, and he was denied his due process as a result. We respectfully request this honorable court reverse the trial court's decision on the motion to suppress, order any and all evidence obtained as a result of the constitutional violation be suppressed and excluded, further request that the conviction and sentence be vacated and the matter be dismissed or remanded back for further proceedings. The last thing I would like to say is the video in this case really does speak for itself. It's part of the record in this case. That video fails to capture any alleged marked lane violation, despite the fact that it runs for probably about 57 seconds prior to the stop. And also the basis for the probable cause, the scratching that was indicated by the appellee of the dog. When you watch that video, it's a 5 to 7 second free air sniff. It happens like that. And the defense expert testified you can't make anything out of that. The dog was rewarded to her. Thank you.
Thank you. We will take the case under advisement, send you a copy of our written decision when it's issued, and you can always find it on the court's webpage. Thank you, and have a good day.